Hey guys, what is up? I'm Aditya Kashyap and today I come up live with a new subject segment that is Bharatiya Sakshar Adhiniyam MCQ series part 1 which is going to be very helpful for your upcoming UP, APO, Bihar APO and judiciary examination. So guys, join the session as soon as you can and be the part of this beautiful family. This session is going to be very helpful for your examination. So join the session soon and then we will start with our MCQ series of Bharatiya Saksh Adhiniyam. Okay guys, so कैसे हैं आप लोग? Hope you are doing good and let's begin with the session. Okay, so before starting the MCQ series, let's recall some of the important fact regarding Bharatiya Saksh Adhiniyam, right? So, Bharatiya Saksh Adhiniyam 2023 is a modern legal framework governing the admissibility of evidence in Indian court. It replaced the 151-year-old Indian Evidence Act 1872 and which ended on December 25, 2000, which enacted on December 25, 2023, right? So the main aim is to decolonize and modernize the justice system by integrating the technology into the legal proceeding, right? So it is a Lex Fori law, which is applicable to the law of the forum in which we apply for the cases. Okay. So let's talk about the structure of the Bharatiya Sakshar Adhiniyam. So it consists of four part, 12 chapter and 170 section. Okay. So this is overview. So it consists of four part, 12 chapter and 170 section. And erstwhile it has 167 section. So let's begin with this is all fact we need to learn. Okay, so let's start with the MCQ series of Bharatiya Sakshar Adhiniyam part 1. Okay, so let's start with the MCQ series of Bharatiya Sakshar Adhiniyam part 1. Okay, so as we all know that it consists of four part, 12 chapter and 170 section. So let's begin with section 1 and 2 of Bharatiya Sakshar Adhiniyam. Question number 1. So circumstantial evidence. What is circumstantial evidence? So circumstantial evidence are indirect evidence. Okay. So it is indicative evidence that does not on its face prove a fact in issue but give rise to a logical inference that the fact exists. So this is circumstantial evidence. Basically circumstantial evidence जो होता है वो direct evidence नहीं होता है. It is an indirect evidence and इसके थ्रू अगर आपको कोई सजा किसी क्राइम को प्रूव करना है then you have to fulfill a you have to fulfill a chain then only you can prove the guilt of the accused. So this is circumstantial evidence, and it is an indirect evidence. So let's move on to question number 2. So evidence under Bharatiya Sakshya Adhiniyam means and include. So what it means and include? So evidence include both oral and documentary evidence. So oral evidence को ही ocular evidence भी कहते हैं. So the right option is option C. So according to section 21E of Bharatiya Sakshya Adhiniyam, evidence means and include both oral, that is ocular evidence, and documentary evidence, right? So this is question number 2. Let's move on to question number 3 of Bharatiya Sakshya Adhiniyam. So question number 3 क्या कहता है? In the law of evidence, fact means and include. So fact means and include what? So fact means and include anything perceived by the senses, state of thing capable of being perceived by the senses, mental condition of the person of which a person is conscious. So all the three are right regarding the fact. Okay, so fact means anything perceived by the senses, a state of thing capable of being perceived by the senses, and mental condition of a person of which a person is conscious. So all of the above is correct. So this means fact. आगे बढ़ते हैं. Explanation ही पढ़ लेते हैं. So section 21F of भारतीय साक्ष्य अधिनियम define fact as anything, state of thing, or relation of thing capable of being perceived by senses and any mental condition of which any person is conscious. So any mental condition of which any person is conscious also fact. Okay, under भारतीय साक्ष्य अधिनियम. And relevant section is section 21F. Okay, so 21F is what? Fact, definition of fact. So आगे बढ़ते हैं क्वेश्चन नंबर 4 की ओर. क्वेश्चन नंबर 4 क्या कह रहा है? A caricature is a document within the meaning of section of section 2 of the Bharatiya Sakshya Adhiniyam. So a caricature is a document within the meaning of section 2 of Bharatiya Sakshya Adhiniyam. So is this statement true or false? So this statement is true, and its explanation is given under illustration 5 of section 21D of Bharatiya Sakshya Adhiniyam. Consider a caricature as a document. So illustration 5 जो है section 21D का, वो caricature को include करता है as a document. Okay. So this statement is absolutely true. So this is question number 4. Now move on to question number 5, law of evidence. So law of evidence क्या है? So it is an adjective law, substantive law, and both. So it is an adjective law, that is a procedural law. Okay. So law of evidence is an adjective procedural law which define the pleading, evidence, and procedure with respect to substantive law, right? So this is law of evidence. Law of evidence is what? It is an adjective law, that is procedural law. Okay, आगे बढ़ते हैं. क्वेश्चन नंबर 6. क्वेश्चन नंबर 6 क्या कहता है? Under the भारतीय साक्ष्य अधिनियम, fact means, so fact means क्या? Fact means both factum probandum and factum probans. Okay, so what do we understand by factum probandum and factum probans? First of all, fact is defined under section 21F of भारतीय साक्ष्य अधिनियम. Okay, now factum probandum and factum probans क्या होता है ये पढ़ते हैं. So factum probandum means the principle of fact to be proved. Okay, so it means the principal fact to be proved, that is factum probandum. And factum probans क्या होता है? So factum probans means the evidentiary fact which follow the principal fact. So it is an evidentiary fact which follow the principal fact. Okay, so it is a means to prove the end. Okay, so आगे बढ़ते हैं. Hope you are clear factum proband and factum probans. Okay, probandum and probans. So आगे बढ़ते हैं क्वेश्चन नंबर 7 पे. क्वेश्चन नंबर 7 क्या बात करता है? क्वेश्चन नंबर 7 कहता है relevancy. Relevancy is what? So relevancy is question of law and can be raised at any time. So relevancy is what? It is a question of law and not fact, and it can be raised at any time. Okay, so in Sardar Sarovar versus Rupinder Singh ji, Daulat Singh ji, 2021, it was held that relevancy is a question of law and can be raised at any stage. Okay, so relevancy is a question of law and it can be raised at any stage, right? So question number 8. Question number 8 क्या कहता है? A fact is said to be not proved. So a fact is said to be not proved when? When it is neither proved or nor disproved. So a fact is said to be not proved when it is neither proved nor disproved. Okay. So this is about fact, and fact is defined under section 21F, okay, of Bharatiya Sakshya Adhiniyam 2023. And there is a question for you. In which what is the date of enforcement of Bharatiya Sakshya Adhiniyam 2023, and what is the date of ascent of the Bharatiya Sakshya Adhiniyam? प्रेसिडेंट एशियंट कब पाया भारतीय साक्ष्य अधिनियम ने और कब से ये फोर्स में है? लेट मी नो इन द कमेंट सेक्शन. अब हम लोग मूव करते हैं क्वेश्चन नंबर 9 की ओर. So question number 9. Law of evidence is. So law of evidence is what? So law of evidence is a Lex 4E law. What do we mean by Lex 4E law? So law of evidence is a Lex 4E, meaning evidence is one of those matter governed by the law of the country in which the proceeding takes place. That means जहाँ पे जो प्रोसीजर चलेगा रिलेटेड टू द केस, वहां पे जो प्रोसीजर होगा उस कंट्री का वही फॉलो होगा. दैट इज लॉ ऑफ एविडेंस, एंड लॉ ऑफ एविडेंस इज लेक्स 4E, दैट इज law of the forum, right? So this is question number 9. Question number 10. Question number 10 क्या कहता है? So question number 10 बात करता है भारतीय साक्ष्य अधिनियम का. So भारतीय साक्ष्य अधिनियम कहाँ पे अप्लाई करता है और कहाँ नहीं? So it applies to proceeding before an arbitrator. So does not apply to a proceeding before an arbitrator. So this is correct, ठीक है ना? It does not apply to the proceeding before an arbitrator. Does not apply to appeal. It is basically a substantive law, ठीक है? ये तो so the correct option is does not apply to the proceeding before an arbitrator. This is correct. Okay. क्योंकि substantive law तो ये तो जो adjective law है, that is procedural law, right? So according to section 2(1) of Bharatiya Sakshya Adhiniyam, the Sakshya Adhiniyam does not apply to the proceeding before an arbitrator. So section 1 sub clause 2 में clearly mention है कि साक्ष्य अधिनियम does not apply to the proceeding before an arbitrator. Question number 11 क्या कहता है? Whenever it is provided in the Indian Evidence Act that the court may presume a fact. So court may presume fact means what? So it may call for proof of the fact. So it may call for proof of the fact is correct answer. Obviously, may presumption में you have to prove that fact. Okay. So section 21H of Bharatiya Sakshya Adhiniyam or erstwhile section 4 of the Indian Evidence Act state that whenever it is provided by this act that the court may presume a fact, it may either regards such fact as proved unless and until it is disproved or may call for proof of it. Okay. So may call for proof of the fact of that fact is the correct answer of section of question 11. So question number 12. Basically हम लोग क्वेश्चन नंबर 12 पे आ गए. क्वेश्चन नंबर 12 क्या कहता है? क्वेश्चन नंबर 12 क्या है? द इंडियन एविडेंस एक्ट वाज ड्राफ्टेड बाय. तो इसमें पूछा इंडियन एविडेंस एक्ट जो 1872 वाला है, जो अर्ड्स वाइल एक्ट था, उसको किसने ड्राफ्ट किया था? तो उसको ड्राफ्ट किया था सर जेम्स एफ स्टीफन ने. सो इट वाज ड्राफ्टेड बाय सर जेम्स एफ स्टीफन. ओके. सो इंडियन एविडेंस एक्ट वाज ड्राफ्टेड बाय सर जेम्स एफ स्टीफन इन 1872. क्वेश्चन नंबर 13 व्हाट इज अ स्टेट? क्वेश्चन नंबर 13 कहता है द फैक्ट इन इशू मीन्स. तो हम लोग फैक्ट इन इशू मीन्स से क्या समझते हैं? वी अंडरस्टैंड दैट द फैक्ट द एग्जिस्टेंस और नॉन एग्जिस्टेंस ऑफ विच इज डिस्प्यूटेड between the party. Okay. So fact in issue means the existence or non-existence of which is disputed by the party. That is fact in issue. आगे बढ़ते हैं. इसका explanation. As for section 21G of भारतीय साक्ष्य अधिनियम, fact in issue means those facts alleged by one party and denied by other in a civil suit or alleged by the prosecution and denied by the accused in the criminal cases. So fact in issue in civil cases क्या होता है? Which is alleged by one party and denied by the other. So this is fact in issue in civil cases. But fact in issue in criminal cases when it is alleged by the prosecution and denied by the accused, and that is fact in issue for criminal cases. And it is clearly mentioned in section 2 subclause 1 subclause G. Okay. तो भारतीय साक्ष्य अधिनियम. क्वेश्चन नंबर 14 क्या कहता है? क्वेश्चन नंबर 14 कहता है द भारतीय साक्ष्य अधिनियम 2023 हैज बीन डिवाइडेड इन, तो ये हम लोग तो शुरू में ही पढ़ लिए थे ड्यूरिंग द starting of the class. So it is consist of 4 part and 12 chapter and how many section? So it consists of 170 section. Erstwhile जो भारतीय साक्ष्य अधिनियम है उसमें कितने sections होते थे? तो उसमें section होते थे 167, राइट? सो अर्ल्सवाइल जो भारतीय साक्ष्य अधिनियम है उसमें 167 सेक्शन होता था, और अभी जो है हम लोगों के पास जो भारतीय साक्ष्य अधिनियम सॉरी अर्ल्सवाइल इंडियन एविडेंस एक्ट हैज 167 सेक्शन, बट द भारतीय साक्ष्य अधिनियम हैव 170 सेक्शन, राइट? एंड इट इज कंसिस्ट ऑफ 4 पार्ट एंड 12 चैप्टर। ठीक है, आगे बढ़ते हैं। होप यू आर क्लियर टिल नाउ। सो क्वेश्चन नंबर 15 क्या कह रहा है भारतीय संविधान में? एन इंस्क्रिप्शन ऑन अ मेटल प्लेट और अ स्टोन इज अ डॉक्यूमेंट। ऑब्वियसली इट इज ट्रू। सो एन इंस्क्रिप्शन ऑन द मेटल प्लेट और अ स्टोन इज अ डॉक्यूमेंट इज अ राइट स्टेटमेंट। So let's read the explanation. So illustration 4 of भारतीय साक्ष्य अधिनियम section 21 D of भारतीय साक्ष्य अधिनियम state any matter described or expressed upon any substance by means of letter, figures, marks, or more than one of those means for the purpose of recording it is considered as document. So, any letter, figure, marks, or more than one of these combination, if those means for the purpose of recording it, then it will be considered as a document, right? So section 21D illustration 4 is the relevant for an inscription on a metal plate or stone is a document. So this is true. And document 21D. Question number 16. So hope you are clear till question number 15. If you have any doubt regarding that, you can ask. I think these questions are very, very basic questions, and it is very, very important for our basic concept clarity. Okay, right? So let's move on to question number 16, right? So what question number 16 state? So question number 16 state in a relation to expression defined in section 2 of Bharatiya Sakshya Adhiniyam, which of the following statement is not correct? So among the given option, which is not correct? So fact include not only physical fact but also psychological fact. It is absolutely true. Court include arbitrator. No, the court does not include arbitrator. So option B is wrong. Court does not include arbitrator. And an inscription on a stone is a document. Obviously, it is a document as per section 2, subclause 1, subclause D. Okay. And illustration 4, right? And a fact is said to be not proved when it is neither proved nor disproved. Absolutely true. Absolutely true. A fact is said to be not proved when it is neither proved nor disproved. And a fact is mentioned under section 2, subclause 1, subclause F. Okay. So this is fact, document 21D, fact 21F. So important definition of today's class. So hope you are clear till question number 16. So we have completed the 16 question. Let's move on to the another part. So question number 17. Under section 2 of Bharatiya Sakshya Adhiniyam, court does not include. What court does not include? So court includes judge, magistrate, and district judge, but it does not include an arbitrator. Okay, that's why the strict rule of evidence is not followed in an arbitration. Okay, can you guys tell me the year in which Arbitration and Conciliation Act came into existence in India? In the comment section. So arbitrator have been left out of the definition of court for parties convenience, right? So let me know in the comment section in which year the Arbitration and Conciliation Act came into force. Okay, in the comment section, please take part in the comment. It will only going to help you in preparing the subject. चलो क्वेश्चन नंबर 18 पे हम लोग चलते हैं. What question number 18 state? Is per section 1 of Bharatiya Sakshya Adhiniyam, the act came into force on. So I have already asked you this question. Let's so इसका आंसर भी आ गया. So it came into force on July 1st, 2024. And in which what was the date when it get the assent of President of India? Let me know in the comment section. So question number 19, we have already discussed this question's half part, and we have already discussed this question in the initial session. So let's read it again. So the Bharatiya Saksh Adhiniyam consists of, so it is consist of 12 chapter and 170 section. So it consists of 12 chapter, 170 section, and how many part? Let me know in the comment section. We have already discussed that. So let me know in the comment section how many part it consists of, and also mention in the erstwhile Indian Evidence Act, which was repealed by the Bharatiya Saksh Adhiniyam, have how many sections? So let me know in the comment section. I have already told you in the class. Now, which of the following is not considered as evidence? Question number 20. इनमें से दिया हुआ क्या एविडेंस कंसीडर नहीं किया जाएगा? Statement of witness or affidavit? So obviously affidavit will not consider as an evidence, right? Statement of witness is an evidence, so the correct option is option A. So guys, this is question number 20, and hope you are clear till now. So we are done with today's session of part 1 of Bharatiya Sakshi Adhiniyam. Hope you liked it, and it is going to, believe me, it is going to be very helpful for you, and it will boost your preparation, and it will boost your knowledge also. So guys, if you like my effort, if you like my work, if you feel that it is going to help you to enhance your knowledge, then please do like, share, and subscribe, and be the part of this beautiful family, that is Aditya Kashyap AGS. And I'm Aditya Kashyap, signing out, taking on leave. We will meet in next session with having CPC series, which we are doing. Okay, so today we will do CPC part 14. Okay, so we have already done 13 part of CPC, and today we will done part 14 of CPC. So this is all from my side, guys. Bye bye, and we will meet you again tomorrow, same day, same time. So bye bye. Hope you like this session. I'm taking your leave. This is Aditya Kashyap signing out.